Yes. So you'll get word from this office.
Okay.
Okay. All right. Thank you.
Thank you.
Okay. 24. Where is it? 29. What's up?
You want to meet that up?
Hold on, let me bench. Well, just a minute.
You want to do the olive?
I guess just we have to do it and just stand by. Yeah, I think that's the
I think it's the last
I
one,
have.
yeah.
Yeah. Okay, so Johnson, do you want to research how to do the marriage certificate? Because I'm pretty sure that they have to notice someone. Yeah. Okay, we have the last case. It is Tanyqua Oliver, pro se tenant appellant versus BTI LLC. Here. Several things. All right, you can sit down, and then you can move the microphone closer to you so that you can be heard. All right, I don't think I said the case number. It is 24XX11. All right, so there are several things in front of me. Hearing, wash. May I have appearances, please? I think I have.
Yes.
Yeah.
Tanyqua Oliver, pro se.
Okay.
Judge Parker Warnell and Dayton Blair on behalf of BTI LLC.
Okay.
Lincoln Carr from Dunn's Bingham Greenbaum on behalf of Judge Davis.
Oh, on behalf of Judge. That's right. Okay. All right. So this is your motion, I believe, or is it your motion? There's so many things going in here.
It's a motion to quash. I mean, I'm more than willing to go first, but.
Well, is this your
I
motion?
apologize. Yes, Your Honor, this is a motion to quash on behalf of Judge Davis, the subpoena that was issued by Miss Oliver.
Let me write it here because I got to do it electronically. Motion to quash. Judge Davis. Okay. That's fine.
All right, Your Honor, pretty simple. We filed our objection to this subpoena.
Right.
And sort of went over it last week, and this was just a motion to quash it from further proceeding after that fact for a simple, this is an appeal and trying to bring in additional evidence there.
Right. Okay. Your response?
Yes, ma'am. I'd like to.
Briefly. I just want to make sure it's brief. I know you usually have a lot to say, so I just want to make sure it's brief, but you are entitled to response. You may continue.
Okay, I know this is an appeal, like they say, but it is pertinent as far as a relevant fact to as far as if this action even had permission to be filed, as it was previously prohibited by a judge, and then a judge opened up the door and canceled or dismissed that prohibition while she was without jurisdiction. And the reason why she was without jurisdiction is because.
Which judge are you referring to?
Circuit Court Judge Tracy Davis.
Okay.
And the reason why she was without jurisdiction is for several reasons. The main one being me being arrested without probable cause in a case of duplicate litigation. Within my motion to strike that I filed on April 26th, I also put in there a motion for judicial notice of adjudicated facts. And I understand that's at your discretion, but I do believe it's pertinent. While I also note that I do not believe, and please, like I said again, last court hearing, please correct me if I'm wrong. I want it placed on the record, but I I wanted this case to be transferred because I do not believe that this court can rule upon a motion to disqualify directed towards the Supreme Court. There was two motions to disqualify that was filed in there, and I'm not sure if there was a confusion with the two. I'm referring to the motion to disqualify that's directed towards the Supreme Court, not the motion to disqualify directed towards Tracy Davis. So there's one that's filed 26A.015, and she denied that one. I'm referring to the one that she, I don't know if she didn't know if it was filed or what happened, but I'm referring to the one that was filed under 26A.020, and that's directed towards the Supreme Court. And the Supreme Court has ruled it has to be handled on appeal by the Court of Appeal. So I don't know if this court can rule upon that. Although I know that that is something that is pertinent to them making a ruling on that. And my purpose of the motion to transfer is to transfer this case and consolidate these cases so they can clearly see if there was probable cause for her to arrest me or if there was not. And I have looked on the record for the duplicate case that Judge Tracy Davis was the presiding judge within, and it does not exist. Otherwise, I wouldn't have issued a subpoena ducis tecum, but it's
Wait a minute, you're saying the tape of the hearing was not available?
the tape is available.
Oh,
The
well.
entire, I have a copy of the entire written record. There's nothing in there as far as probable cause. The only thing I found close to probable cause is the Assistant Jefferson County Attorney, Lachey Ritchie, stating that the courtroom rules had been violated to not record. She did not put a name on it. She did say the courtroom rules to not record had been violated, and then the next hearing, I was arrested for recording the hearing, which I did not do.
All right, BTI, did you want to chime in here?
Pertaining to Miss Oliver being removed from the courtroom that day.
Yeah, or just, anything in general.
I think the record speaks for itself. She was asked repeatedly to sit down. She did not. She disobeyed orders and she was removed from the courtroom.
I think there was some profanity.
No, ma'am. There was no profanity. Actually, when I was asked to sit down, I do have a disability of PTSD, and I stood up and I raised my hand, and you can see it on the video record. And that is November 16th, 2023. I have PTSD, and when my heart rate elevates and my cortisol levels rise, I prefer to stand. I told her I need to stand. I even called 911 while I was sitting right there. She said, "No, ma'am, you need to sit." And then I knew that it was a civil proceeding and that I could forfeit my own case. I knew that I was having a medical emergency. I tried to leave. They barricaded me inside of the courtroom and told me that I could not leave inside of a civil proceeding that I was the petitioner for. If this court would like documentation of my disability, I have that. I would just ask for a moment to, I guess, print that out and give it to you. But I do have a disability and I've had it since I was 9 years old. So.
Okay. Sorry, your response to this, I'm sorry.
You're
Pertaining
fine,
to
Your Honor.
Judge Davis.
Essentially, the record does speak for itself, and judges do speak through all their orders, and everything that she is wanting is public record. And to the extent that she's asking us to basically make up documents, we object. We put that on there, that objecting to the record for that purpose as well.
Okay.
And Your Honor, I honestly believe it does not exist because, like I've already done said, I did not record that hearing. There was no need for me to record the hearing because there was two media sources available that she directed to the jury booth, and one of them was streaming live. I had no problem doing that. And to be honest with you, I have tried to record my own hearing in the past, and I have learned that if that's something I disagree with, then there's appropriate measures to do that. And when she told me I couldn't record, I wasn't going to challenge her decision. I was going to go my own way and figure out, if I need to file this, figure out this. But under no circumstance was I going to sit there and record that judge's hearing after she ordered me not to, because for one, I had my son with me, who is 6 years old, who I was arrested and taken away from.
Yes.
The guy's not here that actually set the recording. He was here last hearing, but it's still live on Facebook, and I got a clip from that. I don't know if Judge Davis looked at that and assumed that, oh, she reposted on her Facebook, she must have recorded. But if you look at the post that I was arrested for, it is the point of view is literally from the jury box where she directed the press to sit. I understand that it can get kind of confusing if you tell one person you can record, another person to record. And I felt like that should have been taken into consideration, and it wasn't. I was just arrested when I raised my hand to even speak to defend myself. I don't know if I upset her or what, but I was not even presented the opportunity to be heard.
Okay. Got the quash. Did you clock and drop this?
The motion
The
for,
motion for emergency writ of prohibition
yes, ma'am.
to stop the eviction?
Yes, ma'am. There is another writ was signed, on April 30th. And it was signed stating that there was no appeal filed in a timely manner. And obviously we're here and there is an appeal. I have no idea why, BTI continues to apply for, a warrant of possession when this is clearly still ongoing. I don't know why Judge Buckner continues to sign it. I know she's probably a busy woman. I don't understand. To my understanding, I read a lot and I can comprehend very well. I am a poetry teacher, but I'm not a lawyer. But from what I read, the process is if you appeal, it's in a stay position until this court rules or you write your own.
I did issue an order saying that my earlier order of staying the execution, the eviction was stayed as the appellate proceedings were moving forward. However, I was mistaken. And so basically you have to perfect the appeal in order for anything to be stayed. You failed to perfect the appeal. It's all in the order. So the original district court warrant for possession stays in effect and the eviction is no longer stayed. So that moves forward. There's nothing that I'm gonna do regarding that, which is why I'm trying to find this in here. There's a lot in here.
Yes,
And
ma'am. I have a question. I don't understand how my appeal is not perfected.
you have to, well, should I, Johnson? I don't know exactly how to explain it, being a judge and not her attorney.
Well, I can say that I understand their you don't have to. I think I know, and they're saying that I need to pay my rent into court. However,
Yeah.
the obligation to pay rent has been terminated as this is a constructive eviction, and I do not lose my right to claim constructive eviction because there is a continuing breach with cumulative effect. I've also, I don't know if you've read my motion, but I actually motioned to strike that. I also motioned for preservation of error. And I exercise the remedies that are within KRS 383.630. Also, that states that rent abates because possession has not been delivered in accordance with KRS 383.590 that constitutes that it must be delivered in accordance with the contract and landlord obligations by law. Landlord obligations have not been fulfilled by law for the entirety of my tenancy. There is active citations on my home, and there have been active citations on my home since August of 2023. I actually submitted a text complaint, which is how we regularly communicated before we switched to email, directly to BTI on my third day of tenancy. And in accordance with our lease, acceptance of the premises is accepted unless you object to it within the first 3 days. I did object to it within the first 3 days, and my complaints have been confirmed through Jefferson County codes and regulations.
I understand, but what was in front of the district court was whether or not you paid your rent. It's never about any kind of repairs that need to be done or any problems that the landlord has done. It is literally the one issue in front of the court. They cannot take up any other issues. It's whether or not you paid your rent. Now, you appealed this judgment because she, she went ahead and signed the warrant for possession. So that, as I said in my order, stays in effect. So that appeal, is finished. There's no longer an appeal on the eviction matter because of the record. You did not follow the appellate procedures, and you didn't perfect the appeal, which means you didn't initiate the appeal because it failed when you didn't pay the rent and all the owed rent into court. And I don't need to hear anything else. I'm going to take everything under submission.
Yes, ma'am. You issued another order telling them they have 30 days to respond after that. So if the appeal was over, why did you issue that order?
I was looking at that. Here, Johnson, did I just make a mistake on this as well? Here.
And then also, I did argue
wait a
constructive
minute, we're
eviction
talking.
to Judge Buckner as well.
It's just that we can't stay the proceedings. Appeal can proceed, but we can't stay the eviction. Does that make sense?
Oh,
So
okay.
she has to pay the bond in order to stay proceedings, but even if the bond's not paid, the appeal still goes from.
Oh, okay. I'm sorry. I thought you had to perfect it. Okay, my staff attorney has just informed me that the appeal is still going forward. However, the eviction is obviously is going forward as well as the appeal has been perfected. Is that your understanding as well?
So,
Oh, I'm getting from the BTI.
Yeah, Judge, that does lead me to another matter of submission, though. We had a motion to dismiss that was amended and refiled on the 11th. I believe it was accepted on the 15th.
On
So
411 or?
on 411, and I
Okay.
think that it was processed on the 15th. It, to my understanding, has been responded to and is right. I'm not sure if the court's ready to rule on the dismissal. It's simply for lack of rent being paid into the court's escrow.
Okay, well, if I can find it in here, I know I saw it. Is it the green one? Aha.
and yes, ma'am, if the appeal is still ongoing, I would still like to strike the warrants for possession because they claim that an appeal is not ongoing. That means that those, if
Well,
the,
no, the warrant for possession is still continuing. That's good. So they can evict you.
but the warrant for possession claims that there is no appeal. Your Honor, I would like to request that you recuse yourself.
Let's see. Well, let me look at this before I say anything else. Oh. Oh, I didn't say that the appeal was, I don't think I said that in that order. Are you looking it up? I can't find it in here. In any event, the crux of the order was that the forcible detainer judgment continues. I didn't dismiss the appellate action. I just remember reversing or remanding my order. And that just saying that the district court judgment is in effect.
Yes, it says the writ is vacated, but the judgment is in effect. So I'm confused. Now you're saying in open court that is not vacated, but your order says it is vacated. Your Honor, I would like a motion again for you to recuse yourself.
Well, I didn't say that the appeal is not going forward in the order. Does that make sense? It was just my earlier order, which said it stayed the appeal. I mean, stayed the eviction. I didn't set aside, and I said that the district court's judgment remained and the eviction is